I request my colleague, Professor Arjit Pandey, to welcome ma'am and start today's proceedings.
Good morning, everyone. I'm Arjit Pandey, Assistant Professor, Department of Law, PIMR, Indore. It gives me an immense pleasure to extend to you all a very warm welcome on behalf of Department of Law, Prestige Institute of Management and Research, Indore. Department of Law, PIMR, was established in the year 2015. Since then, it has been involved in imparting legal education both at undergraduate and postgraduate level, making it an institute of approximately 800 students and more. The institute is an autonomous institution approved by Bar Council of India, New Delhi, and affiliated to Devi Ahilya University, Indore. I'm really thankful to our institute for organizing this National Faculty Development Program 2020 on expected nuances in laws post-COVID-19. The faculty development programs are specific programs designed for faculty members with aim of developing the pedagogical and research skills of the participants. These development programs for faculty members become instrumental in continuously modifying and restructuring their offerings to the students. For today's session of FDP, we are delighted to have amongst us Dr. Sonali Kusum, ma'am. Ma'am is currently working as an assistant professor of law at Tata Institute of Social Sciences, Mumbai, and has completed her Ph.D. from NLSIU Bangalore. Ma'am has been a legal research associate with UNICEF and has been a columnist at AIR Law magazine. Dr. Kusum has been extensively contributing in field of research by writing various research papers and articles in national as well as international journals. Ma'am was invited for delivering a session on Surrogacy Bill by Rajya Sabha Committee on Health and Family Welfare. Her suggestions have been included in Rajya Sabha number 102, 10th August 2016 on Surrogacy Bill 2016. Dr. Sonali has been receiving awards and accolades for her dedication and excellence in academia and research field. We welcome you, ma'am.
Thank you so much.
Our other panelists are Ms. Sayali Bandi and Mr. Gopal Kag, Assistant Professor, Department of Law and Faculty Coordinators of this National Faculty Development Program 2020. We have even Mr. Nakul Singh Chauhan and Mr. Rahul Nima, Assistant Professor, Department of Law, PIMR, as my co-moderators. Today's session is on cooperative federalism issues between center and state in light of COVID-19. Although harmony and cooperation is essential among center and states in order to ensure smooth functioning of the country, but due to this pandemic, the relationship of center and states have been largely affected. To update us with more knowledge about the same, I now request Dr. Sonali Kusum ma'am to kindly proceed with the session. Ma'am, please take the session.
Good morning, all of you. First of all, thanks to Ms. Saili as well as Dr. Joshi as well as all the faculty colleagues who have put together their efforts to bringing out this program. And I also extend my thanks to Mr. Arijit who introduced me very well. And I think now we can formally start with the discussion on the concerned topic. So today we will be discussing the issues of federalism. Now, in the pandemic situation, the most important concept is how is federalism challenged, or what issues are emerging between the center and the state relation with respect to what is already constitutionally ordained, with respect to what are the duties of the center, what are the duties of the state, where are the issues of state independence, where are the issues of state and center interdependence, then how are the constitutional provisions which are already provided are complied by the center as well as the state, and then what are the challenges they are facing in regulating the center-state relation as per the constitution, in managing how pandemic is creating a new kind of a situation, an unprecedented situation between the center-state relations. So now, since federalism essentially involves a concept of center and the state relation. Now, as per our constitution, federalism concept is nowhere defined. There is no definition of the term federalism, as we all know. There is a center-state relation chapter which is there. Now, center-state relation chapter, there are various provisions: administrative cooperation, financial cooperation, a lot of power, as we all know, in our Indian constitutional scheme. Though we have not defined federalism, but we have adopted a mixed model of federalism, a more like where center has little more power, the state has little lesser power, but nevertheless, there are areas where the state has complete autonomy, independence. There are areas where the center has to kind of provide some financial inputs or financial grants to the state. The state and the center has to work together. Okay. So, having set this context as to what is constitutionally ordained, we have another very important thing besides the center-state relation chapter, Article 246, 249, and everything. Besides that, clearly demarcated center and the state relations, the power, jurisdiction in the 7th schedule of the Indian Constitution, right? So, we have union list, concurrent list, state list. The powers, functions, jurisdiction is very clearly mentioned over there, where the state can come in, where the center can legislate, where the center and the state both have to legislate, where are the areas of cooperation. Now, in the context of pandemic, are we following that? How much is the state consultation important in the area of pandemic? Because first of all, keeping in the context of pandemic, as we all know, it is unprecedented. In this situation, how is it that the center and the state relations are going smoothly? Is the state receiving enough cooperation from the center? Is the state receiving enough financial grant from the center? Is the state being consulted? Is the state being excessively monitored by the center? Or is the center kind of overriding the state? Or is the state not discharging its duty, right? So these are some of the issues which we have to keep in mind when we are assessing how the administrative regulation between the center and the state is done or is complied, not complied in the context of pandemic. Now, very essentially, we all know that pandemic or any kind of this epidemic kind of a situation following the COVID-19 requires a very localized approach. It cannot have a very far remote, uniform, centralized approach. Primarily because we all know from the news and from all the reports from all sources that all states are not equally affected by pandemic. Some states in India have a very high record and very high cases of death, very high cases of the places where there are large number of people who are tested positive. So can a center make a law which is uniform and make it applicable without consulting the states and impose it? Can there be a center high-handedness when the context of pandemic is such which requires a localized approach because all states are not similarly affected? And also we have to bear in mind the states know better what kind of a position of its residents are. The states are better equipped, right, to know about what are the essential commodities in that particular state. All states may not have the same essential commodities. For instance, I would like to give an example here. For instance, in the state in like Kerala or in the state like West Bengal, the commodities and the services which are permissible as essential are not necessarily the same which is there in Delhi or in Maharashtra. For instance, in Kerala, they have still permitted newspapers, books and all those things. In West Bengal, they have permitted even the sweet shops to remain open. Now, that is a sweet is an essential commodity for the purposes in Bengal, but it may not be the same for Delhi. So how much the permissible essential goods and services can it be determined by center and can it be imposed on the state? Now, I'll go into some of the essential issues as to how this whole center-state relations are kind of disturbed or there are challenges which needs resolved. There are areas where the center has overstepped. There are areas where the state has not necessarily followed with the guidelines of the center. It has created some issues. To begin with, let's begin with the areas where there have been constitutional violations or there are, if not violations, if we can rightfully say, there are inconsistencies in compliance between the center and the state on maintaining what is there in the 7th schedule. Now, 7th schedule is very crucial to maintain a very good harmonious balance in federalism. It is the keystone of that. Now, in 7th schedule, if you see, public health is a state subject. Very clearly, it is a state subject. There is no dispute about it. We can look into entry 6, list 2 of the 7th schedule. I'll repeat it. Entry 6, list 2 of the 7th schedule clearly says that public health is an area which is entrusted to the state to manage it, independently autonomous, right? So this is an area in federalism where the state has complete autonomy with respect to it. Now, in this regard, health is an issue which the state is supposed to legislate, regulate. Now, as we all know, when the pandemic started, the first 21 days of the lockdown which started was done by the center. All of a sudden, it was not something which was kind of consultative, which was not an issue which was kind of prior discussed, prior deliberated, right? There is no record, there is no documentation as to how all over the country this initial 21 days lockdown started. Now, what are the ramifications of this when the center is not consulting the state, making a uniform lockdown of 21 days in the pandemic without consulting the state? Now, what is the constitutionality of this first 21 days lockdown by the center, unprecedented, without deliberating the states, right? And then what happens? What are the repercussions? The related areas also are affected. Now, there are other subjects also which are in the state list related to public health, agriculture, state jurisdiction, right, under the state list. Then market, essential commodities, liquor, all these shops are after the lockdown immediately shut down. Now, these are also, be mindful, these are subjects which are also under the jurisdiction of the state to regulate, to make law, to policy or anything, or any circular has to be brought. There is a very constitutionally imposed duty. The states have to be consulted. These are areas where the state jurisdiction is central. Now, center brings a lockdown, all these services are shut. Two major implications follow from here. One first implication is the revenue of the state completely dries up. The other very serious impact is on the labor, migrant labor. All of a sudden, as we see in the news reports, and I think everybody's familiar, people started walking because all of a sudden train, buses, flights, everything is stopped. All services are stopped. Now, because of that, what happens? Migrant labor has had to face a huge and a serious gross violation of human rights in every which way. Their right to life, livelihood, food, everything is kind of suspended all at once. And the state has nothing to say, even though the state has well within its jurisdiction to make law, but the state is remaining a silent spectator. That is one repercussion of it. So not only 7th schedule entry 6 list 2 is affected public health, but the related services like market, agriculture, all these things, liquor, everything is shut down. The state revenue dries up. And we all know that while the state revenue is drying up, this is as much as the thing, the state exchequer right now due to pandemic, now the state GDP, each state's GDP is affected as much as the most developed state, the financial capital of the country, Mumbai, that state's also GDP is drying up. Now, how is the state supposed to come out with the repercussions of this and boost its economy, boost its GDP when you completely shut down everything without consulting the state? How is the state supposed to take care of the labor? Now, labor again is a state subject, right? So in the labor regulation also, how is the center bringing out this policy without consulting the state? Now let's come to this constitutionality of the first 21 days lockdown after Article 246 and 7 schedule. Let's come to this. Now, whole legality of this first 21 days lockdown was brought under Disaster Management Act 2005 under Section 11 and Section 12. I'll repeat it for everybody's consideration that it is under Disaster Management Act 2005, Section 11 and Section 12. Now, because we do not have a very clear, comprehensive law on something like this kind of a pandemic, we have a very old law, which is Epidemic Act. Now, Epidemic Act, if you know, there are just 5 to 6 basic provisions, and it was drafted in the era when there was no flight services, because the provisions which are given are with respect to ships and all that, cargo and other things. There is no provision with respect to flight, telecommunication. It was back in the days when there was not much of telecommunication, no advancement of flights and all. So Epidemic Act became completely redundant at one point. Now, Epidemic Act is still imposed across the country, but only selectively. Only those provisions of Epidemic Act has been included where they are related with IPC, where people are stepping out, or if there is a violation of any kind of a circular which is issued by the state. And then during that time, if you violate the lockdown, IPC provisions are, invoked. 269, Section 269, 270 are invoked, because you are deliberately, if you're posing a risk or threat to the society because of your movement and you're violating the government's lockdown regulations, those provisions are invoked. So Epidemic Act, to the extent it relates to IPC, those are invoked. Now let's come to Disaster Management Act, because the first lockdown which started by the government was under Disaster Management Act. Now, under Disaster Management Act, if you go, now I'll bring out the instances where the provisions of the Disaster Management Act also has not been necessarily complied by the center. Okay. Though it is mandated under Section 11 of the Disaster Management Act clearly that the state has to be consulted, a national plan has to be brought out with respect to managing pandemic or managing any kind of disaster like this. The state has to be consulted. The state views have to be taken in record, and accordingly, the center and the state should work together where they can bring out a national plan. The center is supposed to formulate a national plan under Disaster Management Act. That is very clear. But how is the center supposed to have a national plan? There is a procedure also. So the center has complied with the first part of the provision under Disaster Management Act to bring out a kind of a guideline. But the procedural compliance under Disaster Management Act has not been complied by the center, wherein the role of the state is completely absent. What happened is, in this procedural compliance, Disaster Management Act says that you have to consult the states. You have to take their opinion. After that, taking the state's opinion, it should be representative of the state's view. You have to formulate a guideline under that national plan. Now, what happened under this is entire jiffy and entire pandemic, the center brought out guidelines. There is no national plan by the center. If you be reading the acts and the provisions rightfully, you will find without constituting the national plan, you are not supposed to bring out the guidelines. That is how the intent of the Disaster Management Act and the sequencing of the act is. So the procedural compliance by the center is not that. So what happens is you have guidelines, you do not have a national plan by the center. So the center, what is supposed to do, it was under their jurisdiction to bring out a national plan, that it did not comply. The state's opinion, the state's deliberation has not taken place. No consultation in the first 21 days lockdown has happened. So again, Section 11, Section 12, in a way, it is not necessarily complied by the center, right? So as I said, this is a very crucial violation of the center-state relation, especially with respect to pandemic, read with the Disaster Management Act, Section 11 and 12, because pandemic can be managed only better if it has a localized approach. You cannot be sitting at the center and directing the directions, which is what is happening in Maharashtra, what's happening in Bengal. You cannot have that kind of a uniform standard direction, right? Each state is well equipped. They know what percentage of labor is migrant labor. Of course, labor is also state subject. They know how much percentage of the people are affected by COVID or pandemic because of the overall situation, like how many people are, testing positive, how many hospitals and other things you may need. All these things, the state is better equipped, the center cannot. And that is why health is put in the state subject, because it is constitutionally thought also that the state should have a more localized approach in administering health issues. So this is one concern where Disaster Management Act is also violated. So if you see in nutshell, my point was that the constitutionality of the first 21 days lockdown, which started without consulting the state under this Disaster Management Act under 7th schedule, can be subject to challenge. It can be areas where it clearly demonstrates areas where the constitutionally ordained principles are not necessarily complied with. And this is where the first blow to the center-state relation in pandemic is clearly demonstrated. There are various petitions, various articles are written by scholarly people. I think there's enough literature available on the net also, where you can find these kind of issues are being raised. Now, since I have set a general context of the center-state relation, now let me go into the whole concept of what exactly is collaborative federalism about, right? Since I spoke about this general context of pandemic and the first 21 days lockdown, it was very essential to bring out at this point. Now, let's go into the concept of collaborative and cooperative federalism. Now, cooperative federalism is what is kind of implied in the Indian context. Now, as we all know, in law, a bare text or bare provision of the law cannot be mechanically read. You have to see what is the interpretation of those provisions through series of judgments. Now, in the context of federalism, let's be very clear that federalism is a concept which is a part of basic structure of Indian Constitution. Now, federalism, again, is not clearly defined. It is only provided in the basic provision. So in the lack of a definition, we have a description of federalism through center-state relation under Article 246, 249, all those provisions are there, right? Now, if you see, there are judgments which are very important. I would like to pinpoint two important judgments here, which kind of deal with the essence of cooperative federalism, which is kind of implied, right? One is the very recent judgment of Government of NCT Delhi versus Union of India 2017. In that, the term cooperative federalism is used in the Indian context. I hope everybody can reflect it back. It is very much available on SCC online as well as on Manupatra, as well as in Google also you can search. Government of NCT Delhi versus Union of India 2017. This is a Delhi High Court judgment where they clearly use the term cooperative federalism. And there are various names which are assigned: collaborative, pragmatic federalism. These are the terms which are used in the Indian context. And therein they have interpreted the Indian federalism to be collaborative and cooperative federalism. They say that it is about time that the center and the state should work together. There should be a balance between the two. Having said that, they also give a brief description or a definition, or we can say a simple meaning of what is meant by cooperative federalism in Indian context. They clearly say a few important things which are important to understand the concept. First is that there has to be constitutionally ordained principles which have to be followed by the center and the state in their respective jurisdictions, right? They say that it has to mean discharge of constitutional responsibilities by the center and the state in the spheres where they are independent, in the spheres where they are interdependent, but in keeping with the constitutional provisions, not to encroach again on the power of one over the other. Center cannot encroach on the state cannot be delinquent in not discharging the duties, right? Again, areas where the state is independent, autonomous, the state should exercise so that the state does not become a weaker entity in front of the center, because both have to run clearly together to run a very good administrative setup. Again, there are both, if you see a negative concept to this cooperative federalism. One, the negative concept is one should not encroach upon the other. And the other positive concept is there are areas where they're interdependent, they should work in accordance with the constitutional principles, right? So this is in essence what is described in Government of NCT Delhi versus Union of India 2017. If you see, the Government of NCT Delhi versus Union of India also derives the concept from what was given in the landmark previous judgment of State of Rajasthan versus Union of India 1977. In the State of Rajasthan versus Union of India also, there were some grains and initial primary concepts of cooperative federalism, wherein they spoke that where the center and the state are independent, interdependent, sticking to the principles of constitutionally ordained ideas of center-state relations and all that. Now, after this 2017 judgment, it is very important as to how we are looking at the center and state relations, especially in the context of pandemic. So, in the present context, how are we seeing this cooperation is maintained? Is there cooperation or during the pandemic between center and state relation, or is there high-handedness or imposition of the center's power over the state? This is an issue we have to kind of deliberate upon, that in the management of pandemic, is one encroaching or one cooperating? And most importantly, are you really sticking to the constitutional principles which are there? Are you really going with the judicial directive which is provided through series of judgments? So this is a context as to understand why it is important to understand, first of all, what is cooperative, collaborative federalism. Because a lot of times it is kind of a misnomer to believe that in India federalism is not defined and federalism means more power to the center. That is a wrong notion to have, because when you have a judgment, and we all know in law, the judgments provide meaning and the purpose or the essence of what is there in the constitutional provisions. Constitutional provisions cannot be read mechanically, we all know, I think, from being from law fraternity. So this is important to bear in mind. Now, let's go to some other issues and challenges with respect to managing pandemic between the center and the state relations. As I spoke of 7th schedule in Article 246, which is clearly violated in present context, I demonstrated that some time back. Now let's go into the issue of Article 249, very important provision with regard to center and the state relation, right? Article 249. Now Article 249 clearly says that the center can make law even on the state subject, right? So people who could say or who would have a different view upon it, they can well argue that the center, when it brought about the lockdown, it was in the public interest, it is in the national interest, they are well within their right to do so. Nothing defies that, we don't disagree with that. But in Article 249, very clearly, there is again a procedural compliance which is there, that the center can make law on the state subject, provided the state consultation is taken. There is a resolution passed by the state also by 2/3 majority, right? Now, if you say that the lockdown is brought about by the center in the initial 21 days without notifying the state, where is the state consultation? Where is the ratification by the state of by the 2/3 majority? So that is again absent. So as much as 7 schedule, entry 6 list 2, 246, article 246, article 249, these all the three, if you see, they are not areas where the center has complied with the procedural compliance. The states are not consulted. And that is why we now have reached a stage which is such a, that our migrant laborers and everywhere, the most marginalized section of society has to face the brunt. The states were not prepared, the states were not consulted. All of a sudden, this lockdown is brought, and a huge implication on the labor, especially the labor implications on the man, on the women, on the children, it is huge. And it's reached a stage where there's a gross violation of human rights. So now, having said that, now we come to some other areas also besides constitutional provisions. What are the areas where, again, center-state relation is effective? With respect to finance now, let's discuss some issues with respect to the finance also, where, because the major means to control a pandemic or regulate a pandemic is where if the state has funds and the resources to kind of manage and regulate the damage which is done by pandemic. Now, state funds or the state has to be made empowered and has to be made more resourceful in order to manage the pandemic right now. As I said some time back, that the center has initiated the lockdown without consulting the state. All of a sudden, agriculture, industry, market, transportation, all these things which are more of a state subject are shut down. Liquor, shops, everything are shut down. What happens directly because of this is the state exchequer dries up. The GDP of the state is completely, on the decline, right? So during this time, the center is supposed to provide some financial grant to the state so that the state can manage. Now, if you see, just a series of contrary other developments have happened by the center, which kind of blocks the financial assistance to the state. Now, let's begin with the very first thing is that GST dues, right? We all know GST has been imposed. Now, GST is a very huge revenue for the state government also. Now, what has happened is that the GST dues are still not paid by the center to the states, to the extent that many state governments have clearly written to the center, the state of West Bengal being the primary one. There have been data where it has been shared where the states have clearly indicated the amount of the GST balance which is pending. Now, through the recent news reports, I have collected that to the extent of 1,000 crores of rupees are kind of pending to the state. Maharashtra being, or the Karnataka or other states, they have an estimate of around some 4,000 crores dues or 8,000 crore dues, which are pending with respect to GST from the center to the state. So the GST dues which were supposed to be given at a particular time, those dues are also not cleared by the center, and it has run in huge amount. Maharashtra being one of the most developed state has a 16,600 crores dues or more. It is an estimated account which I have taken from the media. They have said that the 16,600 crores and above GST dues are pending from the center to the state. Karnataka has quoted around estimate of around 6,000 crores. Kerala has estimated around 8,000 crores. So many, even West Bengal has estimated around 3,000 to 4,000 crores GST dues which are pending. Now this is something which is a huge setback for the state. Now we come to another scheme, MP LAD scheme, right? MP LAD scheme, this is another very important source of revenue for the state. Now what has happened recently by the center is the state center has suspended the MP LAD scheme for the next 2 years. And what it has done is it has merged the MP LAD scheme with the Consolidated Fund of India. Now merging MP LADs with the Consolidated Fund of India goes completely to the center. So all the funding which is coming to the state is going directly to the center. Now again, this is another financial blow to the state because another major chunk of financial resources and revenues are deprived to the state. Now, Let's come to the another important financial scheme, that is the Fiscal Regulatory Budgetary Management Act 2013. Fiscal FRBM Act in short form, Fiscal Responsibility Budgetary Management Act 2013. Now, under this, the states were supposed to receive some amount of fiscal deficit from the center to the state. Now, usually that amount has to be low, right? But recently, due to pandemic, the fiscal deficit grant, which is to be given by the center to the states have demanded that the fiscal deficit grant amount of withdrawal limit or borrowing limit for the state from the center should be, hello, am I audible?
Yes, ma'am.
Hello?
Yes, ma'am.
Okay. Yeah. So I'll continue. So the under FRBM Act, the withdrawal limit or the borrowing limit of the states, they have asked that it should be increased from 3% to the 5% amount. Now that has not also been granted. Now fiscal deficit at this time is very, very important because the state is running much more expenses than it was supposed to be estimated amount, right? The states is deprived of the revenue, right? Because all the major sources of revenue are deprived. GST is not there, liquor shops are closed. Then again, your labor activities are completely closed, agriculture is closed and all that. MP-LAD scheme is suspended. So under this time, fiscal deficit under FRBM Act was a very key resource where the states could have been empowered. Now under this, the fiscal deficit, again, the limit of 3% to 5% demand has not been complied by the center. Now, read with this, I will propose another issue, that is the 15th Finance Commission. 15th Finance Commission terms of references. Under that also, what happens is, it is given to the center that whether the center wants to grant the revenue deficit to the state, right? So even if the states demand some amount of revenue deficit from the state, from the center, if the states demand also, it is left to the center's discretion if they want to grant or not. Now, if you see, there is a this FRBM Act and the 15th Finance Commission terms of references, if you read these two together, you will see there is a centralizing trend towards, where the center will have more finance at its disposal, at its discretion, and it becomes very much, it kind of leads to a monopoly where the center will decide with respect to grant of funding to the state. Even though there is pandemic, even though it is very clearly established that the GDP of the states is worst affected. And also you have to bear in mind that the state funding is very much required because the state has most or major issues with respect to welfare when it comes to managing pandemic, like labor, health, all these things require funding. All this requires resources with respect to the state. If the state do not have the resources, how will they have more kind of, quarantine centers? How will the state set up quarantine center? How will the state manage hospitals? How will the state have more social workers to conduct testing and all those things? How will the state pay the paramedicals? And as well as, because of all these FRBM and 15th Finance Commission, if you please read these two together, you will realize a lot of issues are flowing out of that also. Now, the salaries of the people, government employees, other employees are affected, right? The state is not able to pay because the state does not have any source of revenue right now much. So this leads to another issues of violations, right? So these are some issues in nutshell with respect to the finance. Now I'll come to another very crucial legislation, which is the Companies Act, right? Which is much spoken right now, the issue in the Companies Act. Companies Act 2013 with respect to CSR, Corporate Social Responsibility. Now, this is a very, very crucial provision because under Companies Act, CSR has been made mandatory for certain industries which have a net worth of 5 crores or a turnover of 100 crores annually. CSR is mandatory. They have to do CSR activities and then they get some tax exemption with respect to it. Now, under this Companies Act circular, April 2020, the Ministry of Corporate Affairs have brought about a circular under Companies Act 2013, which clearly states that any kind of grant with respect to PM CARES fund, okay, will be considered exempted for any kind of taxes, right? Whereas the state chief minister's relief fund, right, they are not exempted for tax. So any contribution if you make to the PM CARES fund is exempted and it will be considered as CSR activities. Basically, the Ministry of Corporate Affairs circular of April 2020, it lists activities, it lists kind of certain points where what kind of activities are identified as, permissible activities which can be granted tax exemption with respect to managing pandemic. Any contribution if you want to make, right, with respect to pandemic and all that, or what kind of CSR activities you want to make, the companies want to do, right, for showing their contribution that they have done, right, with respect to pandemic. So now in this regard, all sorts of contribution done by the company, individual or whatever, it is kind of granted exemption under the CSR, right? It will be considered as a CSR and granted exemption, but the same thing is not allowed for the Chief Minister's Relief Fund, right? So now what happens is, under this also, all the grants, all the contributions are going to the PM CARES Fund, not to the Chief Minister's Relief Fund. Now this particular proposition itself is very, very contested. Under Companies Act also this can be challenged. The very first challenge with respect to this is under Companies Act, where there are provisions of making CSR mandatory. It is very clearly stated what activities are, there's a schedule to the Companies Act where they have listed what sort of activities can be considered for CSR. Under that, there is no kind of a restriction or limitation that they should be only allowed for the center and they should not be allowed for the state. I think it lacks rationality. It can also be challenged under Article 14 because things which are similar in nature have to be treated similarly. It is very much ordained in the Article 14 also, it can be challenged. When under Companies Act schedule clearly says that hunger, poverty, all these issues, any kind of health related issues, labor welfare issues with respect to women's welfare, all these things can be considered to be CSR activities, right? And they can be granted tax exemption. So during pandemic, if these activities are done by the center, then it is entitled. But if the same activity, the nature of activity for the same purpose, it is done by the state, then it is not granted. So under Article 14, reasonable classification, Article 14 clause 2, reasonable classification, this can be very much challenged as to how, on what basis, what is the rationality when the purpose is same, when the objective is same, and when under Companies Act, the nature of activities is listed, there is nowhere a restriction for the state that the state cannot the state cannot be benefiting from the exemption, while the center doing the same nature of activities it can be. So this is first, under the Companies Act, it can be challenged. Article 14, reasonable classification, it can be challenged. Now coming again to this whole, now coming to the whole constitution of PM CARES Fund, right? Now PM CARES Fund also is a very disputed and very contentious issue right now. What is being discussed and deliberated is right now, I think everybody is aware, there are lots of petitions which are being filed. There's a petition by M.L. Sharma, there is a by Advocate M.L. Sharma, there's a petition by senior lawyer Prashant Bhushan, there's a petition by some of the law students from Allahabad where they have said the whole constitution of PM CARES Fund itself can be, the legality of constituting it completely redundant and completely arbitrary. It can be challenged on the ground that when you have a national relief fund, why the need for PM CARES Fund, right? Again, this can be subject to Article 14 reasonable classification. For the same purposes, when you have a national relief fund, why is it that you need another PM CARES Fund for the same nature, same purposes? What is the basic purpose? What is the reasonable objective that you are trying to receive? In fact, under Disaster Management Act, we have, if you see, this is the area also which shows a lot of policy overlap and inconsistencies. See, on one side, our government is saying repeal the law, the laws of India are redundant, there are too many laws, labor law is made into code. But at the same time, when you have two laws of the same nature, why are you making more laws? When you have National Relief Fund, you have Chief Minister's Relief Fund, you have Companies Act and everything, CSR activities, then why PM CARES Fund? You wanted to, the policy initially was to repeal the law, to make the law more simple, clear and easier. Then why again another act which does not, which could have the objectives and the purposes could be served? So why this extra or additional law? Now under this PM CARES Fund, directly all the contributions are exempted. There is no RTI which is it can be subjected to, right? So, and the constitution of the committee, it is made into a trusteeship, right? All of a sudden this act, then again, why this cannot be read with the Disaster Management Act? Why it has to be read with standalone? Under Disaster Management Act, Epidemic Act, when you're reading Epidemic Act with IPC, Disaster Management Act also you're reading with IPC, other policies. Why this PM CARES Fund has to be read very separately? Why this new creature of law which is constituted? And for what exact purposes? For pandemic. when you know that pandemic is a very serious issue at the state level, ground level, right? People are affected. The states have no role to play. How is it serving any purposes? And how is it, and the PM Cares Fund, the portfolio which is given of the members is the Prime Minister, the ex officio chairman of the PM Cares Fund trustee. Then there is Home Ministry, Defense Ministry and all that, right? So how is it that the state's participation is there? And when you know that because of all these things, the state revenues is affected, it is the people and the subjects is the states have to manage. Labor, health, all these are state subject. And nothing of that reflects in the PM Care. So how the rationality and the logic flows. So these are issues which are very crucial as to how during the pandemic, these are some problems which we are facing or which the state is facing, and thereby the citizenry is also facing, and thereby the human right violation or all legal right violations of this, state subjects are also taking place, because there is no balance or there is no harmonious relationship. From the provisions I read out and the illustrations I brought out, you can see that the idea was from the NCT Delhi versus Union of India, having independence in the area where they are entitled to under constitution, and the areas where they're supposed to be interdependent. So the areas where they're supposed to be interdependent, like GST dues, MP-LAT schemes, or FRBM Act, they were areas where there was interdependence. Those are suspended, right? On the contrary, where they're supposed to be independent, 7th schedule, public health, labor, Article 246, 249, there is no interdependence, there is center high-handedness. So how are we going to manage the pandemic? How is the administrative relation going to be smooth? Now, let me bring you to another important committee report, which is very, very crucial at this time to kind of reflect, is Punchi Commission. Punchi Commission 2007, which very clearly read all the relations, like after Sarkaria Commission was a very elaborate and detailed center-state relation report, Punchi Commission was also brought about to simplify and to bring out very specific points how the center-state relation could be made harmonious, right? Now, under that, they spoke of interstate council. A very crucial body, interstate council in the constitution also is provided. Interstate council should be constituted. Now, in the entire deliberation in the pandemic management, we are reading so much. If you see the media reporting, there is only PM Cares Fund, or there is public health issues and all that. 246, sometimes 249 issue is brought about. There is no mention of interstate council at all. Nobody is talking about Punchi Commission and the recommendation. Where did it go? Punchi Commission clearly says that when there are issues which affect the state largely, in those areas, the interstate council should be given the mandate, the interstate council should discuss, right? And also the center should deliberate and discuss and have kind of a policy consultative debates with the state. So where is that? The whole debate with respect to invoking interstate councils and all that, that is completely missing. Now, Punchi Commission recommendations are completely kept on view. Now, another important thing where it could have been proposed is also these are some of the areas where we should reflect. Where is the effect to 73rd and 74th Amendment? Where is the role of the local authorities? The panchayats or the municipal bodies, are they well empowered? Now, of course, it consequentially eventually flows that when the state does not have the fund, when the state does not have resources, how will your local authorities get the funds? So, but under, as I said, now you go back to the idea of what was given in the Disaster Management Act. The center brought about the initial 21 days lockdown under Section 11 and Section 12 of the Disaster Management Act. Though it was clearly stated in the Disaster Management Act, the state has to be consulted, guidelines have to be formulated. Center brought about out of three things. The center did guidelines, did not bring national plan, did not consult the state. Now, where is the role of the state? Where is the role of local authorities therefore? So what about those local authorities? So that's again something which needs to be brought about, which needs to be empowered, which needs to be reflected upon. Now, another important crucial area is the Niti Aayog. If you see, Niti Aayog Planning Commission was there earlier. We did away with the Planning Commission because the idea was the Planning Commission को हटाया गया या उसको replace किया गया, तो ये कहा गया कि क्योंकि Planning Commission बहुत centralized approach रखता था, ये center में बैठा है और state center is not completely familiar or well adequate with the requirements of each state, because each state, as we all know, we are a secular state, so demographies and all those varies. So the needs and requirements of the states has to be different. So we will have Niti Aayog, which will have more power to the state. The states will have much more, voice or representation there. Now nobody is invoking or speaking about these policies from Niti Aayog with respect to pandemic. Now it is only dealt with Ministry of Corporate Affairs, this Companies Act, CSR, this PM Cares Fund. Niti Aayog, which was very much constituted with the idea that the states will have much more clear voice or representation, because as we all know, it is not affecting all the states equally. Some states really need a lot of support, and in terms of finance, in terms of even empowering them with the social and health and other labor inputs and all that. So those states, they would have represented their needs, right, if the Niti Aayog policies were constituted, but that is not there. So in a nutshell, these are some of the issues which I would like to kind of pinpoint. And I think I've spoken enough. So I think I would like to take questions if anybody has. And thank you all for your patient listening, right? And I hope this was an effort from my side to bring about the issues in the contemporary context and what are the challenges. So I just brought about the challenges. See, it's not well within my right to also to propose recommendations with respect to this, but I can only say that some of the recommendations which we can reiterate is that Kunchi Commission should be reflected upon. It is about time that we reflect what was given in the Kunchi Commission 2007. Interstate councils have to be invoked. Disaster Management Act Section 11 has to be reread again. A national plan has to be brought about. It's been 4 or 5 months since the initial lockdown and we still do not have a national plan. Epidemic Act has to be a lot more revised. A lot of reforms and additions have to be made with respect to regulating airports, with respect to regulating telecommunications and other things. And again, Niti Aayog, local authority, 73rd, 74th Amendment. These things have to be again re-invoked, reconsidered, so that the center and the state relations are much more harmonious. And since it is a pandemic, we have to bear in mind the states have much more a crucial role. These are areas which are touching upon entirely state subjects, right? So I think it's about time that the center deals away with certain amount of imposition and high-handedness attitude and brings about the state and empowers the state so that it can, center and the state both can, in a better way, they can regulate the pandemic. Thank you so much for all of you, to all of you for your patient listening. And I think I would like to take questions now. Thank you.
Thank you, ma'am. My name is Nakul, and I'll be helping you out with the question and answer round. So we've asked the participants to post their questions on the chat box. But other
can you speak a little louder, please?
Yeah, ma'am, my name is Nakul, and I'll help
Yes.
you out with the question and answer round.
Yes.
And we've asked the participants to post their questions on the chat box. But
Okay.
I would like to inform the participants that you can raise your hand and we will unmute you so that you can directly interact with ma'am.
Okay.
So let's just wait for a minute if there's a hand raise. Otherwise, we'll take up the questions from the chat box.
Yeah. I will just go through the chat.
Yeah. So we just have one comment from Dr. Vishal Ranavare as of now.
Yes, yeah. I am reading that. Yes. Yeah. So that's an observation and a comment. That's not a question.
It's not a question, right?
Yes. Yeah. I hope it has been some amount of information exchange from my side to the rest of the participants. I hope, though I know it is a Sunday and it is like morning session. So I hope people are warm to the idea.
Oh, okay, ma'am. There's a hand raise from Ms. Afreen Khan.
Yes. Okay, there is another. Okay, that's also again a observation only, not a question.
Okay, Afreen, you can speak now.
Yes.
Good morning, ma'am.
Yes.
This session was
Can you be a little louder, please?
Yes,
just a little louder, please.
Sure.
Yeah.
Am I audible now?
Yes, yes.
Yes. This session was really informative. My question is regarding the role of judiciary.
Okay.
What has been their role in understanding that how the center has had this upper hand in the whole pandemic? Whether they have taken a stand or not in this?
Yeah, okay. Thank you for the question. I would like to say, good that you brought about, because we discussed all the other issues in elaboration. So, see, as I said, there have been 3 petitions which have been filed. One petition by Advocate M.L. Sharma with respect to, the issues with respect to regulating center and the state relations during pandemic, with respect to setting up PM CARES Fund and why the contributions cannot go to National Relief Fund and why the exemption is not given to Chief Minister's Relief Fund. So concerning these 3 issues largely, there is one petition by Advocate M.L. Sharma. The other is by Advocate Prashant Bhushan. The third petition is by some 4 students of Allahabad, so law students of Allahabad. All the 3 petitions, I'm very sorry to say, they have not been admitted by the Supreme Court, right? So this is the clear response of judiciary when they have not admitted the matter itself for hearing. How do you address that, how do you say that the judiciary can do anything? Because if you're not admitting the matter, right, you're not willing to adjudicate upon a subject. So I think the role of judiciary is also, I'm sorry to say, but it appears very passive right now, because if you're not admitting the subject matter for hearing, how is the role of judiciary to be invoked? Though it is in the issues of migrant labor, in the issues of, for instance, controlling the pandemic, they have taken some cognizance. In the issues of pandemic, again, like, there is a petition with respect to migrant labor, in real miseries of migrant labor and other things. There is a petition before the Supreme Court is issuing directions also. But with respect, particularly with respect to the fund, right, the constitution of the funding, the issues of funding, because right now in pandemic, what has become very significant is how will the state manage this kind of a disaster when the revenue of the state is completely dried up? How do you manage that? For that, the Chief Minister's Relief Fund has to be very much empowered. And if that is not happening, on the contrary, some other fund is created. On the contrary, GST is not paid. All these things are done. So during this time, these issues could have been admitted by the judiciary, but since it is not admitted by the judiciary, there's a complete silence. Though selectivism is there in the judiciary right now, when they are hearing the matters of migrant labor, they are hearing issues of prison inmates, they are hearing issues with respect to children, they are hearing issues with respect to human rights issues in general, but these kind of issues are not admitted. So this is what I can say about the judiciary. Passive and selective, I think.
Thank you, ma'am.
Thank you.
We have another question from Mr. Rahul Supani. So first of all, he says, do you think that the directive principles of state policy should be mandatory for the successful implementation of a federal structure? And in the second portion, he's just, bagged with an example. So I think if you answer this question, it will answer.
Yeah, see, right now it pretty much appears that in the present situation, because of the kind of lack of law or the legal void and the unprecedented, the nature of how pandemic is being managed by the center and the state, and there is a fiasco, it appears so, rightfully, as Mr. Rahul has pointed out, should we make directive principles mandatory? But I would like to disagree from this, because directive principles is not necessarily only one part. Directive principles, if you see the genesis of directive principles in our constitution, comes from Irish constitution. Directive principles are largely they are to do with the state. They deal with economic, social and other issues, right? It largely deals with the economic, social issues. So now economic, social issues are policy related issues. Now policy related issues are different from fundamental freedoms, right? Fundamental freedoms are by nature human rights. They pertain to individual. So fundamental rights, similarly, directive principles cannot be necessarily made into rights. To the extent directive principles pertain to individuals, they have been made mandatory. Like you have said, like right to education and all, they have been made into fundamental right. They are made mandatory. But to the extent directive principles relate with economic, social policies like Article 39 and all that, it depends upon the state, because it requires a certain amount of social economic development of the state to give effect to those provisions. Where we are saying under Article 39, social economic policy matters, like the state should also be given equal distribution of resources between the center, the state, and checking concentration of power or finances in few hands. All these things cannot be directly made mandatory because it requires that amount of development. These are developmental rights or developmental policies. So in order to make it mandatory, it will require a lot of development first to take place. So these are subject to enforcement depending upon progressive development. If you have that much resources, then you can implement. So making it mandatory, I don't think so. It will serve a practical purpose. It will have its own challenges because it requires that much development to take place. Yes.
Ma'am, we have a hand raise from Dr. Vishal Ranavre. I'll just allow him to talk.
Yes.
Sir, you'll have to unmute yourself.
Thank you, sir. Thank you, ma'am.
Yes.
It was a wonderful session.
Thank you.
During the
Yes.
problems which you highlighted in this session, I just have one question, that is, what is the future of this Indian federalism? Because when we adopt this federalism, concept of federalism, some that time politicians, they were also favoring the unitary mechanism. But we go with the federalism, and now we are facing so much issues with the federalism. So what do you think? What is the future of this federalism system in India?
Okay, thanks for the question. See,
I hope it is clear to you.
yes, the question is clear to me.
Oh,
The
thank
future of federalism in India, what is the scope or what is the lookout? So I think, see, federalism in India has been introduced in the Indian Constitution after much deliberation. If you go to the Constitutional Assembly debates, they have adopted a model of federalism where center, of course, has been given little more powers, but at the same time, the idea has been the state should not be made dependent, should not be made weaker. And now with the judicial interpretations like NCT Delhi versus Union of India 2017, one of the trend which is coming in place, since you spoke of futuristic thing, we are moving towards what is collaborative and cooperative, consultative or pragmatic federalism. So as much as the center will have power, the judicial interpretations are towards the way that federalism is a basic structure. It cannot be done away with. No government can come and, just overhaul it. Yeah, there have been attempts by the government to centralize and to move towards centralization. That is an approach by the government. But there comes the role of judiciary also. But judiciary so far has not kind of, reflected or built upon it. So the other thing is, there is the trend towards collaborative federalism, pragmatic federalism by the court judicial interpretation. So if you see, the judiciary is about the view that consultation has to take place. It is no more center overriding, state being weaker. It is not, it has to be consultative policy making. Another clear example is the setting up of Niti Aayog. See, earlier planning commission was done away with the whole idea, because planning commission, it was said that the center has high-handedness, the center is not aware of the each state's needs. उस समय ये बहुत बड़ी बात हुई थी कि जैसे केरला जैसे स्टेट या वेस्ट बंगाल जैसे स्टेट्स, इनके नीड्स रिक्वायरमेंट्स अलग हैं. They are more culturally more rooted. There, for instance, Kerala has a very high rate of literacy. So now there, अगर वहाँ पे आप पैसे दे देते हैं बेटी बचाओ बेटी पढ़ाओ के, वो completely redundant है, क्योंकि केरला में literacy rate तो अच्छा है ही, वहाँ पे जेंडर का बायस उतना नहीं है. हरियाणा को जरूरत है बेटी बचाओ बेटी पढ़ाओ शायद ज्यादा की देन केरला. So if you were giving earlier the central government and the planning commission, they were giving the grants equitably. कोई भी नई पॉलिसी आती है सेंट्रल गवर्नमेंट की तो एक सर्टेन अमाउंट ऑफ पैसा सबको इक्वली मिल जाता है. Then we got done away with this idea and we brought about Niti Aayog. Niti Aayog का पर्पस ये था कि स्टेट को पॉलिसी मेकिंग में ज्यादा इन्वॉल्व करना. So when you have Niti Aayog, where you have the concept of pragmatic federalism coming from judiciary, I think there is a scope for moving towards improving the federalist structure, moving towards harmony. But definitely the road towards leading that is faced with a lot of challenges. And during this pandemic, we are seeing a lot of issues, right? I think it is first of its kind. One of the reasons why the center-state relation during pandemic is affected is because हमारे पास पहले से कोई well-prepared, well-comprehensive planned law नहीं था. We still do not have under Disaster Management Act, उसमें clearly एक plan की बात कही गई है, national plan, which is supposed to be policy-oriented with the states and all that. Section 11-12 clearly states that the plan अभी तक नहीं बना. National plan क्या है with respect to disaster? क्योंकि उस टाइप का हमारे पास law नहीं है. We do not have a law. See, entry 23 covers disaster also under 7th schedule of Indian Constitution, जिसके अंतर्गत Disaster Management Act को लाया गया था. But right now, since we have not invoked all those things, the legislative prior groundwork has not been done. So it is kind of, moving little helter-skelter. That's what I can say. And therefore, it is posing challenge to the federalist relation. I hope I have answered your query. Hello. Hello.
Actually, he put his mic on mute. Sir, you can unmute your mic again. Ma'am is asking whether your query has been resolved. Yeah.
Yeah, ma'am. Yeah, thank you for that.
Thanks.
And I think federalism is not just a creation of center and state governments. It's all about the distribution of power, giving autonomy to state to resolve their own issues.
Yes.
But right now, the current situation is because of this GST and all those things, state is more dependent on center, and the center is not willing to help those states where they are not in power. For example, in West Bengal and Maharashtra. So they're really helpless.
Also. If you're speaking of
Yeah,
that,
Kerala.
you might as well include Kerala.
Kerala also.
Yes.
And
see, that is always there.
as I am
जो
from
भी law
Maharashtra,
होता है,
I can.
Sorry, I was just saying that see, nothing is apolitical. एक saying है, nothing is apolitical.
Yeah.
भी apolitical नहीं होता है. So law, constitution, judiciary, everywhere politics come into play. So nothing is apolitical. So disaster, pandemic is also not apolitical. So I think that is also a way of putting it across.
Thank you, ma'am.
Thank you.
We have one final hand raise from Dr. Anita Gehlot.
Yes.
I'll allow her to speak.
Sure.
Ma'am, you'll have to unmute yourself now. Anita, ma'am.
Hello.
Yes, ma'am, we can hear you.
I'm audible?
Yes. Please go ahead.
Good morning, sir and ma'am.
Good morning.
Thank you for informative session. Ma'am, my question is related to power, division of power described under Constitution.
Yes.
So in pandemic COVID-19 situation, is power again revised?
Okay. See, with respect to pandemic, there has been, like you mentioned, constitutional provision. अगर आप 7th schedule of Indian Constitution देखें, तो disaster itself को concurrent list में लाया गया है. Entry 23. Entry 23, disaster is the subject under concurrent list. So both center and the state is empowered. Now, with respect to disaster को regulate करने के लिए Disaster Management Act उसी Entry 23 के अंतर्गत लाया गया है. Disaster Management Act 2005. और उसके अंतर्गत अगर आप देखें Disaster Management Act Section 11 और Section 12 में, उसमें clearly center और the state का role बताया गया है. जैसे कि अगर Section 11 कहता है कि the center is empowered to bring a national plan with respect to regulating disasters, well within the power of central jurisdiction, central government. Then we come to Section 11 Clause 2. इसमें clearly ये कहा गया है the center is supposed to consult with the state governments and bring about a kind of a policy consultation. और उसके बाद, having formulated the national plan, guidelines are supposed to be issued under national plan. तो Section 11 Clause 1, 2 को अगर ध्यान से पढ़ते हैं तो उसमें सेंटर और स्टेट दोनों को पावर दी गई है. सेंटर को प्लान बनाना है पर स्टेट को कंसल्ट करके, और वो जब कंसल्टेशन हो जाए तो एक गाइडलाइंस आएगी. पर हुआ यहाँ पे एक्चुअली व्हाट ट्रांसफॉर्म्ड एंड व्हाट हैपेंड हियर इज सेंट्रल गवर्नमेंट इन्वोक डिजास्टर मैनेजमेंट एक्ट. पहले 21 दिन का लॉकडाउन निकाला गया, गाइडलाइंस दे दी गई, मिनिस्ट्री ऑफ होम अफेयर्स को, डिफेंस को, सबको गाइडलाइंस आ गई, पर प्लान नहीं बना, स्टेट से कंसल्टेशन नहीं हुआ. और आप सिंस आपने वो कॉन्स्टिट्यूशनल प्रोविजंस और डिवीजन ऑफ पावर की बात की है, सो आई वुड लाइक टू ड्रॉ योर अटेंशन टू आर्टिकल 246 एंड 249. जैसे मैंने कहा, आर्टिकल 246 में अगर आप देखें, एंट्री 6 लिस्ट 2 जो है, लिस्ट 2 स्टेट लिस्ट, उसमें पब्लिक हेल्थ स्टेट सब्जेक्ट है. तो पब्लिक हेल्थ पे स्टेट गवर्नमेंट को सबसे पहले प्रायोरिटी है पॉलिसी रेगुलेशंस ये सब लाने की, और उसमें स्टेट ऑटोनॉमस है. उसमें स्टेट अपने स्टेट का हेल्थ रेगुलेट करने के लिए स्टेट को ऑटोनॉमी दी गई है. पर ये हुआ नहीं इनिशियल लॉकडाउन में. सेंट्रल गवर्नमेंट ने ही एक अनाउंस कर दिया, उसके बाद सब कुछ सर्विसेज इफेक्ट हुई. दूसरी चीज, आर्टिकल 249 भी आप दे सकते हैं. आर्टिकल 249 में कहा गया है कि सेंट्रल गवर्नमेंट को पावर है टू मेक लॉ ऑन द स्टेट सब्जेक्ट, प्रोवाइडेड स्टेट से उसका रेजोल्यूशन पास हो, 2/3 मेजोरिटी ऑफ द स्टेट असेंबलीज, द स्टेट्स हैव टू सपोर्ट इट. तो वो भी नहीं हुआ. स्टेट assemblies in the state support of 2/3 majority did not reflect. तो कहीं पे भी वो जो प्रोविजन थे 7th schedule 246 249 डिजास्टर मैनेजमेंट एक्ट का जो भी प्रोविजन है, जहाँ सेंटर स्टेट का क्लियर रोल था, उसको फॉलो नहीं किया गया. इट वाज इन अ मच हेस्ट. द पैंडेमिक ब्रोक आउट, एक गाइडलाइंस आ गई, प्लान नहीं हुआ, स्टेट सब्जेक्ट क्या है, सेंट्रल क्या है, सब कुछ बहुत ओवरलैप सिचुएशन हुआ, एंड इट हैज लेड टू दैट फियास्को व्हिच इज वी आर फेसिंग राइट नाउ. यस,
Thank you, ma'am. Well explained.
थैंक यू.
With this, I think we can conclude the Q&A round. Ma'am,
Thank you.
before I pass on the virtual mic to my colleague to propose a vote of thanks to you, I would like to
Yes.
thank you for supporting us. There was a scheduling conflict, and you agreed to, change the time for our convenience. So thanks a lot. And I would also like to thank all the participants, because Sunday is the only day where you don't have the tension of setting an alarm to wake up, but yet all of you managed to come and attend a session at 9:30. Finally, I would also like to say that all the participants, once the meeting is over, you will automatically be taken to the Google form for your feedback. If you are unable to fill it in that way, then a link will also be shared on the WhatsApp. So we have automatically integrated the Google form with the meeting, and you will be directly redirected to that Google form after the webinar is over. And if you're not redirected, then we'll also share a link in the WhatsApp group. So I request all the participants, all the respected faculty colleagues to fill their feedbacks. And now I pass on my virtual mic to Professor Rahul Nima to propose a vote of thanks.
Thank you, Mr. Nakul. Thanks a lot.
Thank you.
Good morning, ma'am,
Yes.
and good morning to all. I deem it a great honor and privilege to propose a vote of thanks on this FDP session. I, Rahul Lima, on behalf of Prestige Institute of Management and Research, Department of Law, first and foremost, thank our special guest, Dr. Sonali Kusum, ma'am, who, despite of her busy schedule, has found time for this FDP session. I must mention our deep sense of appreciation to you, ma'am, for your explanation on this topic, which has been utmost importance in the time of pandemic. Thank you for the interactive and informative session. I thank all the participants present here for accepting our invitation. I also thank to our department in charge, Dr. Nishant Joshi sir, and I also want to thank Dr. Gopal Kak sir, Professor Sayali Bandi ma'am, Nakul Chauhan sir, Arjit Pandey sir. Thanks to all. Once again, thank you all for your attention.
Yeah, I would also extend my thanks to Ms. Saili because she initiated and she deliberated. And of course, Professor Joshi, because he, I think, brought about the link and he brought the whole thing in place. And to all my colleagues who are present here this morning with me and assisting and carrying this presentation, Mr. Nakul, Mr. Arjit Pandey, Mr. Rahul Nima, thank you so much. And it's been a great, discussion this morning. And I think this is my second interaction on this academic exchange with respect to pandemic here with your institute. And it has been great coordinating and getting in contact with you all. And thank you all the participants for being here and for your patient listening. And if you have questions further, you can still mail me sonali.kusum@pis.edu, sonali.kusum@pis.edu. Thank you all.
Thank you once again, ma'am. And with this, we'll be ending the meeting. Thank you once again, everyone, for joining us. And now you can take your afternoon nap. You have our permission.
Thank you.
Thank you. Thank you, everyone.